Hi everybody, I'm James Borchardt and I'm talking today about patent protection for new product development. I'm going to do a little bit of a general IP overview, but focusing mainly on patent protection this morning. For those of you attending the webinar, if you have any questions throughout the webinar, just type your questions in the question section, and then we'll get to as many questions as we can at the end, depending on time. So, just to kind of kick off the discussion, I wanted to talk a little bit about sort of what we think about IP protection as it relates to new product development, because a lot of companies are developing technology in a lot of different ways and in a lot of different spheres, and not all of it is sort of categorized or traditionally thought of as new product development. And new product development IP protection has some unique wrinkles. So, the first thing to think about when you're considering new product development is the improvements tend to be incremental. These aren't the types of, they tend not to be the inventions that are happening on a totally blank canvas. They're an improvement on an existing product or process. That doesn't mean they're not valuable, but that drives some particular IP considerations. For instance, they can be more difficult to obtain a patent on simply because there's lots of prior art out there, lots of similar technology. It also tends to be more important when you're thinking about patent protection for new product development to keep an eye on the cost to benefit analysis. Because you're inventing an incremental improvement, the improvement tends to have a limited value because there are all of these earlier competing products that somebody could use if the price associated with your invention is too high. So really keeping in mind the value of your improvement over the prior technology relative to the cost of IP protection is very important. Sort of the third big component that comes up in the new product development space is the simple fact that with most new products, once they're out on the market, it's relatively easy and relatively cheap for a competitor to see exactly what you're doing and copy it, right? There's not a lot of secrecy once your product's out on the market. It's kind of the rare invention that a smart competitor company can't buy your product and figure out how it works. And then the fourth sort of big component is when you're developing new products, there tends to be a lot more interaction with third parties outside of your company. So whether that's outside design firms or your sales folks are going out and meeting with customers, showing prototypes, there's this interaction with third parties that has IP implications that maybe it doesn't typically happen in the sort of core R&D development space. So just as an overview, these are kind of what we think of as the 6 main legal mechanisms for protecting technology and the investment in new product development. So trade secret is a type of intellectual property. It's governed by statute. And the key for trade secret protection to apply to a particular type of technology is it must be kept secret. So, this typically doesn't apply to new product development simply because you're selling your product on the open market and it can't be kept secret. In addition for trade secret protection to apply, it has to be, the subject matter has to be subject to reasonable steps to maintain the secrecy. And the other key component is that trade secret protection only protects against misappropriation. So somebody has to do something wrong to get at your trade secret for it to be a violation of trade secret. And one of the key things that I run into with clients all the time is reverse engineering. Barring some very specific set of contractual relationships is not misappropriation. It's totally fine when your product's out on the market to go for a competitor to go buy the product, take it apart, figure out how it works. So, trade secret tends to have a limited scope, a limited role in protecting new product developments. So trademarks, most people are familiar with trademarks. Trademarks are the brand, logo, product name. A subset of trademark protection is called trade dress protection, and it essentially functions the same way, but it's the look and feel of a product that becomes associated with the particular brand, the particular source of a product. Trademark and trade dress protection can be very, very important in the new product, to a new product, but it tends not to be related to the technology itself. You know, it's sort of the brand that goes along with the new product. And we're not going to be talking too much about trademark protection in this talk. Copyright protection is a type of intellectual property that provides protection for original works of authorship, and it protects those works of authorship against copying. Copyright also has sort of a more limited role in new product development. It tends to be related, tends to come up where new products have a software component. Copyright will protect the code that is, you know, that your device is running if it's a software type device. It also protects product drawings, CAD drawings, and your product documentation, which can be relevant to stopping somebody doing something that you don't want them to do with those documents, but it's not going to stop somebody from seeing your product on the open market, making their own competing product, and competing without copying something covered by copyright. Contracts are kind of overlooked, I think, a lot of times when people talk about intellectual property protection, because it's not a traditional form of intellectual property per se, but it's very important in the new product development space. These tend to be, you know, these are contractual relationships with suppliers, developers, customers, and in particular related to your technology and IP. The two big categories of agreements are confidentiality or non-disclosure agreements and joint development agreements. And we're going to talk a little bit about these in more detail later in the talk. But the thing to remember here is contracts are good, they're good to have, but they don't protect against parties that aren't a party to the contract. So they're only good against your contractual party. And then patent protection, which is the main thing we're going to focus on, are subdivided into design patents and utility patents. So as we go through the discussion, I think it's important to kind of keep in mind some of the goals of technology and product protection. Really what we're looking to do in this space is limit the ability of third parties to compete for your business. We're looking for ways of limiting your customers from replacing you as a supplier. And then we're also looking at ways of creating risk that we can impose on the competitors and customers if they decide to compete. And these are, you know, if you keep these in mind as we go throughout the talk, these are the things we want to, you know, if we're designing a patent filing strategy, these are the things we want to keep in mind. This is an important, it's almost an aside because it doesn't really fit in particularly well anywhere. But something to keep in mind is that your competitors can't do something with your information that you don't want them to do if you don't give them the information. And so just maintaining the actual secrecy of your technology and your information is a very strong type of protection. It's obviously, you know, it doesn't work once your product's out on the market, but it can be very effective in those early stages where you are interacting with suppliers or potential customers. You know, look for ways just to keep your information secret. Limit the disclosure of part drawings, product schematics, CAD files, mold drawings, you know, to the extent possible. And you know, if you can, never give that information out, or don't give it out until you have a non-disclosure agreement, or, you know, even better, a supply contract signed. And the thing that I run into all the time is really consider, why does your customer or supplier need this information to evaluate the business relationship? They don't, in most cases, they don't need your part drawing. They don't need to know every bit of information that you need to manufacture the part. You know, kind of the scenario that we're worried about here, and it happens more often than I'd like, is the situation where our client develops a new product, comes up with some great engineering drawings, responds to a bid, puts out a bid proposal. They put a bunch of money and effort into developing the product. The potential customer takes those drawings, part of the bid process, ships them out to all the other potential parties. Those parties come back with bids that are lower than our clients, and the reason they can do that is they didn't have to spend the money developing the product. They just got our part drawings and said, oh yeah, now that I know what you want, you know, we can make that, you know, for a certain price that undercuts us. And you know, one of the best ways to limit that eventuality is just not give out that detailed engineering drawing. Force, excuse me. Force the other companies competing for the bid to do their own engineering work. So, you know, as we discussed earlier, contract protection of technology is can be very important, and this tends to be broken out into two categories: confidentiality agreements and development agreements. You know, the confidentiality agreement is an agreement that limits the permissible uses that a company, a receiving party, can use with your information. Excuse me. So confidentiality agreements are very important, particularly when patent protection is not being sought. And that's because without a patent being filed and without an agreement in place, you don't really have any rights to control the use of the information that you disclose to the third party. The other potential value for confidentiality agreements is one of the key limitations in the patent process is the effect that a public disclosure has on your ability to file for patent protection. So in many foreign countries, once an invention is publicly disclosed, you no longer have the right to pursue patent protection. Having a confidentiality agreement covering a potential disclosure basically makes that disclosure to a third party a non-public disclosure. Joint development agreements basically are agreements that you have with a third party that controls who's going to own what IP and the use of that IP down the road. This can be very important to do at the outset of a relationship, because at the outset of a relationship, the sort of the success of the product is speculative. We don't know how successful the product's going to be, how much money is at stake, and what we found is that if you try to go back, you know, 2 years down the road when this development, you know, is the next big thing, it can become very difficult to sort out who owns what without a big fight. And kind of the underlying legal issue that drives this is that under U.S. law, the default ownership of an invention is in the inventor, is in the person who came up with the idea. In many cases, that default rule is changed by an employment agreement, which in effect means that if an employee at your development partner comes up with an idea, your development partner owns the IP in that idea. So it's better to get these issues of ownership sorted out at the beginning. But one other thing to remember when we're looking at using contracts to protect technology is that these are just contracts. So when there's a breach of contract, your remedies are contract remedies. They're not they tend not to be as strong as the strong IP remedies of treble damages and injunctions. And so, you know, at least when we're doing a contract that we know is high stakes, where it's worth a little bit of effort thinking it through at the beginning, it's worth spelling out what remedies you want at the outset.
Good question. Is there like a threshold for determining when, like, any clear defined threshold of when contract protection would be sufficient and when it's worth kind of making that next step into thinking of other more protection?
So the question is there a clear threshold of when you rely solely on contractual protection to protect your invention versus utilizing other IP forms, particularly patent filing? And the answer is no. It's you know, the difficulty with sort of looking for bright line rules is that you know, sort of the facts in every scenario differ a lot. You know, it depends, you know, who you're working with. It depends how much money you're investing in the development. It depends, you know, how important you think the particular development is. It depends kind of what your place is in the market. And we'll kind of talk a little bit more about, you know, how to think about those in the patent strategy context a little bit further on. So when we're looking at the patent system and effective use of the patent system, it's important to remember that early patent filing is very, very important. On March 16, 2016, the U.S. switched from a first-to-file patent system, or switched from a first-to-invent patent system to a first-to-file patent system. And what that means is that the first party to file a patent application gets the patent, regardless of who invented first. And there's a few little caveats around that. But as a general rule, if you win the race to the patent office, you get the patent. So, you know, if you know, company A invents an invention 6 months ago, doesn't file patent application until today, Company B invented 1 month ago and filed their patent application 2 weeks ago, without some very specific facts occurring, Company B gets the patent, and when that patent issues, they get to preclude us. They get to sue us for patent infringement and potentially preclude us from the market with an injunction. So it's important to keep that in mind. Another thing to keep in mind is that patent filing before public disclosure can also be very important. So most foreign countries prevent you from filing a patent application if you have publicly disclosed your invention before you file the patent. And in the US, we have what's known as a grace period that allows you to publicly disclose your invention before you file, but there's a lot of nuance into exactly how that exception works, and it's relatively new law, and so how some of that these nuances are going to play out are open questions. And so really the best approach, the safest approach, is to file patent applications on anything that's important before you publicly disclose the invention. So we're going to talk about the two main types of patent protection that are relevant to new product design. These are design patent protection and utility patent protection. Design patent protection is a type of patent protection that only protects the new and non-obvious, and those are legal terms that that speak to whether you're entitled to a patent on a particular design, but it only protects the new and non-obvious aesthetic look and shape design of your product. It does not protect the functionality of the product. That's utility patents protect the functionality. Design patents tend to be particularly useful in preventing knockoff. If you're in an industry where your products tend to be sort of taken off the shelf, scanned, molds made, and an exact replica is produced, design patents tend to be very powerful tool in that sort of scenario. They tend to be less powerful when there's similar looking products, but the products that look different when people kind of evaluate the product side to side. Design patents tend to cost less than utility patent protection to pursue. Probably on the order of 5, 10, 20% the cost of a utility patent protection. They move through the patent office very quickly. It's sort of the rare design patent that takes more than 2 years to get through the patent office. It's also sort of the rare design patent that doesn't get granted as a design patent. It happens every once in a while where, where you're pursuing something where you're trying to be really broad and creative, but for the most part, they fly right through the patent office. And like with all patent protection, you want to file early and before public disclosure outside of the company. And it's important to remember that even though the design patents tend to be relatively narrow and they just protect the look and feel of the product, there are some products where the look and feel is incredibly valuable. Kind of the example that everybody has been using for the last 2 or 3 years is the example that came out of the Apple-Samsung suit. That was a suit over a design patent basically covering the glass-to-edge look of the iPad and iPhone. And Apple was awarded, I think it was $400 million, which was reduced after appeal to a paltry $290 million. That's not a bad return on investment when the design patent probably costs $4,000 or $5,000 to file. This is an example of a design patent that I like to use because most people recognize this product, and it illustrates one of the very important aspects of pursuing design patent protection, and that's the interface between design patent protection and trade dress protection. So trade dress protection, as I mentioned earlier, is a type of trademark protection that allows you to prevent somebody from using a similar looking design when your design has achieved, when it's basically become a brand or source identifier in the minds of the consuming public. So how a design patent works in that context is you're able to file a design patent when you come up with a new design. The design patent gives you a 14-year period of exclusivity while your product's on the market to stop other people from using a similar design. That then allows kind of the sufficient period of exclusivity so that the consuming public associates a particular design with your brand, and by the time that 14-year period is up, you've now established your design as indicating your source. And then the trade dress protection extends on after that, and trade dress protection lasts as long as that brand identification exists, and it can last forever. So here, I can't remember the filing date of this, but I think it was in the early 80s. This is the Listerine bottle. This was filed. Now, I think Johnson & Johnson now owns this company, owns this brand, but they have a trade dress registration on this, and this is a pretty powerful pretty powerful design. You can't put scope in a bottle that looks anything like this without running into some trouble, I would expect. So utility patents protect the new and non-obvious functional features of your new products. Utility patents are typically considered as providing more robust protection than design patents because they in essence limit, because they protect the functional aspects of the product, they tend to limit competitors from getting close to the functional advantages that your products provide. Utility patents cost more than design patents. The costs vary quite a bit based on the type of technology, how many features are being protected. So there's a wide range in cost for filing a utility application. And then prosecuting a utility patent through the patent office is a much more involved process than a design patent. There's usually multiple back and forths with the patent examiner, providing arguments about why your invention is worthy of a patent, and that also increases costs. Utility patents tend to be slower than design patents. They typically take on the order of 2 to 5 years to move through the patent office. There are some that go quicker, and there's outliers that have been pending for 10, 15 years, but 2 to 5 years is a pretty good range. And we'll talk a little bit about why that timing is relevant when you're considering patent protection later on. And the other thing to remember is you can, if you need patent protection sooner, there's some ways of accelerating this process. There's a few petition routes where if your inventors are over a certain age, you can accelerate prosecution. And you can also pay a fee to the patent office to accelerate prosecution. So for about $4,000, you can get a final decision from the patent office within a year of filing. Like design applications, it's important to file early and before you disclose outside of the company. I keep hitting on this because it's an important thing to keep in mind. So with that overview of kind of the legal regimes that we're talking about in mind, I want to get into some of the details about how a company can effectively utilize patent protection as part of their new product development process. I found that working with my clients, it can be really important for a company to establish a process, and it doesn't need to be super complicated with a big manual, but having a process in place that lets the business make good business decisions related to patent protection can be important. Because we see, without a process, we see two things happening, and they kind of overlap. One is that without a process, there are valuable innovations that your company is creating that is going unprotected. And kind of the worst case scenario, and the thing that I hate to see, is when a client comes to me, they've got a really good idea, they've got a good product, but because they didn't have a process in place, it's been more than a year from the trade show where they sort of launched the product to the world, and then we're pretty much out of luck. So having a process helps you capture these good concepts before something like that happens. The other thing that we see that happens is, without a process in place, the decisions to file patent applications tend to be driven by the interest of the inventors and the engineers working on a project in the patent process, because they become the advocate. They kind of push, they push the decision makers to move the process forward. And while that's probably better than not filing on anything, you end up filing patent applications based on the advocacy of the engineers rather than on a sort of coordinated business decision, weighing all the costs and benefits, weighing where a particular new product development falls relative to all the other developments that your company is working on. So these are just some sort of high-level points that you should consider when you're looking to develop sort of a patent development, patent capture process in your company. And how you actually do this in your company is very company specific. I think the main thing you want to do is figure out how to fit this into something you're already doing, because your company's already taking lots of steps to make good business decisions. So this is just another business decision that needs to be made when you're developing a product. So figuring out how to weave some of these things into an existing process, I think, is more effective. It tends to be easier rather than coming up with like a special process, a special patent committee or something like that. Sort of one of the key features that I think all successful processes have is they develop a point person to coordinate the patent process. And if you're a big enough company, multiple people for different divisions or product lines to kind of develop the patent, to coordinate the patent process in their sphere of influence. But having somebody who's in charge of coordinating is very important. Coming up with a set of triggering events for when your organization starts to consider patent protection is very important. And this has a process component and it has a training component. So the training component involves making sure that your people know what the trigger points are so that they're presenting the information in a timely manner. And then also the process component is having the process in place so that these discussions are happening. The triggering events are also very company and industry specific, but some things that we like to see our clients looking for are the aha breakthroughs. And if you spend any time talking to engineers, these are happening and the engineers know it. They'll tell you, you'll sit down in a meeting and they'll be like, people in this industry have been working for years to solve this problem. And I was tinkering around and I did X, Y, and Z. And all of a sudden I realized that, we weren't getting that problem anymore. So, when your engineers have it, that's a good indicator that they've hit on something that's patentable, valuable, and should at least be populated through your patent development system. One of the other things we like to identify are the solutions to problems that our customers are having. It seems pretty obvious, but the customers are, will, as they're working with a product, they'll express, they'll identify issues when they're using the product. And when you solve those issues, because it's something that your customer wants, that kind of gets a higher rank on the potential for patent protection scale. Solutions that lower cost. When a development lowers cost, that should be sort of a triggering event for having the patent discussion, because if you can protect something that lowers your cost, that provides you a competitive price advantage relative to your customers. And then for big design projects, most companies will have a design process with different design milestones. It's very simple just to have a line item in those meetings that says, because you have everybody around the table when you're going through, reviewing the design milestones. Have we developed anything we think is important enough to consider patent protection? And that sort of ties into just how you implement this. And probably the simplest way to do it is just to build the patent discussion into your periodic design review meetings. And that's not a one-size-fits-all. Depends how your company does development. But having it as part of a meeting that you're already having works pretty well. And kind of when when everything's percolated through the system, you've got some potential ideas, sort of the initial vetting has been done, that's when you want your in-house or outside patent counsel to get involved to kind of start crafting a particular strategy, talking about kind of what the costs involved are going to be and that sort of thing.
regards to cost justification, is there, with that, would there be kind of a say, you know, if there's development or new technologies and
the question is whether there's a sort of a cost threshold where you would consider, you know, I guess where filing patent protection sort of becomes an automatic. And I think the answer is probably yes. There is a point, but that point is going to depend. It's going to depend on the company and the industry. So there's not like a generic thing. When you look at the survey data, and we have some, and it's mainly for big companies, sort of the ratio of IP spend to, it's usually compared to like development spend. It varies from like 0.1% in some industries to like 15 or 20% in other industries. And that depends on, you know, the size of the companies, kind of the scope of the development. I mean, you can imagine a pharmaceutical company that's spending, you know, whatever they're spending $4 or $5 billion to develop a new drug. Even if they're spending $1 million to pursue patent protection, or more, $10 million, that's still a very small percentage of their overall spend. I think the main thing is you just need to go sort of case by case and see what makes sense. And the thing is, business people that are doing this, they can make these decisions. Your business team can make these decisions because they're doing it already, right? They're deciding, is a particular development worth tasking 200 hours of engineering time? They're making the decision about whether the particular development is worth spending $40,000 on unit tooling. They already have this return on investment calculation, and this just you know, the IP should just be part of it. I think as lawyers, we don't necessarily know exactly how the clients are weighing that ROI calculation in each instance, but your clients do. So I guess that's kind of, however you're deciding to spend the engineering time, apply that same formula to your IP spend is probably about as good as we can do. So when you go through the process and you've identified some ideas about, some ideas that might be worth patent protecting, and you're deciding whether or not to file for patent protection, and when you're designing the process, it's really important that you work with the business folks at your company to identify what it is they really need you to do with this patent portfolio. It's important to understand what the competitive landscape looks like, and that's a broad term, but I guess, like, is your business, are you a big fish with lots of other competitive advantages? That kind of, you know, that weighs into the patent filing decision. Are you a small company that's kind of fighting tooth or nail to eke out your sphere of influence when you're surrounded by big fish? Who are your customers? Are they bigger than you? Are they smaller than you? Do you have the wherewithal to defend a patent infringement lawsuit, or to pursue a patent infringement lawsuit? One of the other things to consider is what's the filing profile of the competitors in your industry? What does that look like? Are your competitors filing patents on every incremental innovation? If they are, you might need to think about an aggressive filing strategy, because you're sort of losing an arm. You could be losing an arms race. Is no one filing patent applications? Maybe that means you don't have to. It also might mean there's an opportunity to take a more aggressive stance. But these are, you know, very case-specific factors that you want to think through. You know, this kind of gets to the previous question. What does the market potential of the new development look like? That's sort of a key thing to consider. You know, if potential revenue is $5,000 a year, it's probably not worth spending, you know, $20,000, $30,000 on a patent application. Maybe it is, but you know, that would kind of weigh against it. What's the expected length of the product technology life? You know, there's some industries that move very fast. A product's obsolete in 12 months. patent protection probably isn't your friend in that scenario because your patent is going to issue 3 years after your product becomes obsolete. Now, on the flip side, if it's a product that has a 30-year lifespan and you get to reap the reward of the full term of patent protection over the life of that patent, you know, that kind of leans in favor of pursuing patent protection. We kind of touched on this, but you know, what's the investment being protected? How much are you spending on R&D, marketing, equipment related to the development? That should all factor in to deciding, to developing the patent filing strategy. And the last one is kind of a, you know, it's specific to a certain type of company. Tends to be smaller companies, startup companies that are, you know, part of their business plan is to sell the company down the road, or potentially to have a big investment from, you know, a big player in the field. So considering, you know, how to design a patent portfolio to increase your company's valuation can basically drive some different nuances. So with kind of those business objectives in mind, you know, you want to basically tailor the IP objectives to those business objectives. So, you know, are we creating barriers to market entry by competitors? Are we really looking to increase risk, impose costs on competitors entering the field? Are we looking to increase risk or impose cost on customers that are switching suppliers? And this one, we run into that with some frequency here, that at least in my practice, where you know, there's a lot of competitive companies that are putting out bids for a particular type of product. If you're a company with patent protection on an aspect of that product, your customer has to ask the question, am I going to accept the risk of a patent infringement lawsuit, you know, to switch suppliers? You know, and they, in a lot of scenarios, they need to save quite a bit of money to take on that extra risk, or they need to have a really good reason to need a new supplier to take on that risk. But if you don't have anything, if you don't have patent applications pending or you don't have issued patent protection, your customer doesn't have that additional factor to consider when deciding to you know, switch to a new supplier. So, you know, looking to develop a high-value patent portfolio to increase company valuation, you know, is kind of one of the more interesting things that we do, and that's an area that's really really company-specific, and it really relates to an analysis of, you know, what the company's technology is and who the potential purchasers or investors are. So that's all the good stuff about good reasons to pursue patent protection. The big hurdle that we all have to face, particularly when we're talking about new product development, is high-level patent protection is often not available. This is the scenario in, you know, many industries, definitely most industries that I work in. You know, for instance, if a company invents a new material or new angle on a windshield wiper blade, your patent protection is going to be limited to those very specific features, and you're not going to preclude everybody from making windshield wiper blades. And so a really close evaluation of the value of your improvement relative to the costs of pursuing patent protection is how you make good decisions in this space. This is just a diagram to kind of explain my windshield wiper example. So, you know, let's just say that the red box is the product design space. That represents all of the potential features that all windshield wiper systems may or may not have. And in that space, there's old designs, there's new potential designs nobody's come up with yet, there's bad designs, there's good designs. And in this rather generous, we came up with a really good new windshield wiper because we're precluding like half the product design space. But areas 1 through 6 kind of represent potential functional features that could be covered by utility patents. And then, yeah, maybe windshield wiper is not a great example. But and then there's 5 kind of aesthetic features that could potentially be covered by design patents. And so, how we talk about utility patents being broader, they tend to cover more features than the design patents. But just because you've developed a product and you're not going to get patent protection that is collinear with the red box doesn't mean you shouldn't think about it. Because, in the Apple example, let's say that iPhone glass to edge design was D2. You could imagine a y-axis on here that's value, and that value just shoots right out of the page. And to the extent you can work with the folks in your business to identify those features, figure out what's valuable, doesn't mean you should just kind of say, oh, we're not filing patent protection because we've invented something very narrow. That might be the case, but you would at least want to say, is our narrow invention really valuable? And then if it is, make sure you identify it and protect it appropriately. So in the new product development space, this patent filing strategy, when it's done right, can be very valuable. And we've kind of touched on these because they're kind of interspersed throughout the various considerations. But if you have patented even narrow features that your customers really like, that decrease costs of manufacture, that makes the product work a little bit better, and particularly if you have a couple of these things built into your product and you have patent protection on those, what each one of those things does is it kind of forces your competitors to, kind of pushes them incrementally towards inferior products. So you can imagine here, if we have patents on all these circles, your competitor wants to make a competing product. They buy your windshield wiper. They look at it. They're like, okay, so they've got this great new blade angle, and well, but they've got a patent on that, so we have to change the blade angle. And so then let's say they're pushed out of circle 5. Then they have to evaluate, did they land in circle 1, or are they in the white space adjacent to it? And that whole process is reasonably difficult, and it imposes a risk on them for competing for your business. And kind of in the best case scenario, they give up and go make the old product, and your product is better. Outside of just forcing them to inferior products, your competitors have to just have to deal with the risk. They have to accept a business risk associated with your patent portfolio when they decide to compete. And dealing with and kind of understanding the magnitude of that risk becomes more difficult the more patents are in the portfolio, and sort of the more sophisticated the filing strategy is. So you can kind of you can use your patent portfolio to make competing with your product seem less like something your competitor should do. The same sort of analysis happens when your customers are considering switching to a new supplier. So they have to do the same sort of thing that the competitors do. And then the potential impact on company valuation. This is actually something that is very important to some clients. There is a thought that a sophisticated patent filing strategy provides a signaling value to potential purchasers. And kind of the thought, and I've heard this echoed by a number of people, is that when a potential purchaser or investor looks at a small company or a startup company and sees that their patent portfolio is in tip-top shape, it does provide some comfort. The thought process being, if they're doing this kind of complicated, expensive thing, you know, as well as they are, they're probably doing all the other stuff right. And then the other thing is the last point here is that in some industries, if your goal is to be sold to into a big fish in that space, they might not need to buy you if you don't have patent protection. And you know, the thought here is that if, for instance, if you're a medical device startup company, you've come up with a great new hip implant. Once that product's on the market, the big medical device companies, they've got a bunch of engineers, they've got a supply line. They can probably take your invention and make it better than you can. And the only reason they need to do business with you is if you have IP protection that prevents them from doing that. So particularly for companies in that sort of space, IP protection can be critical. And this is just sort of a last point that could probably be a presentation all by itself. Outside of considering patent protection for your own product when you're doing new product development, you also want to consider, are you doing the proper due diligence to make sure you don't step right into one of your competitors' patents when you bring your new product to market? And this is something that your patent attorney can help with. You know, there's a bunch of ways to search competitor patents relative to your new development and just see what's out there. You know, one of the important things here is it's very valuable if you're going to do this, if you're going to take steps to mitigate patent infringement risk. It's important to do it early in the process before your product is finalized, because if you identify any patents that are out there, you can adjust your design, or you can adjust your design to avoid infringement, and you're doing it before you've made a big investment. So, you know, you don't want to find the killer competitor patent when you've already spent $1 million on your assembly line. It's better to do that early on. All right, thank you for attending my talk. Now I'll open the floor up to questions. Okay, we've got a couple questions from the webinar. I guess we've got time for about one question. The question was asked, I've heard that there have been recent developments in the law related to software patents. Can you still file a patent application for a software invention? The answer to that is complicated. And so, yes, you can still file. Software is not per se unpatentable under the recent case law. That being said, certain types of software, particularly software in the financial industry, or that are implementing, I mean, sort of the test you see the court saying is if they're implementing things that people do in their heads, is becoming very difficult to get a patent on, and they're pretty much all being found invalid by the courts. Now there are software inventions that are embedded in devices. So if you're inventing software that is, you know, operating a assembly line or an MRI machine or something like that, that's even becoming difficult to patent, but it stands on stronger ground than sort of the business method financial type software patents. The other thing that I would say is that this is a very fluid area of the law that continues to change. There's always rumblings about amending the patent statute to address this. So I think, you know, kind of the smart advice is if you're inventing in one of these hard to patent spaces, and your invention is important enough to kind of, you know, use every means to protect your position, you're better off filing and seeing if Even if you're in the space where it's going to be very, very difficult, you're better off filing and seeing if the law changes, see how the Patent Office implements these new court decisions, see if the statute is amended, because it's highly unlikely if the statute is amended that the public bar limitation would be raised. So this might be sort of a file patent application or lose it scenario. So file a patent application, hope things change, or lose it. So you know, companies inventing in this space, have a pretty tough decision to face, but I think that's the best you can do. All right. Thank you.